Alright, let's get started here. Alright, hello everyone. My name is Christian Townsend, and I'm the president of Untitled Chapter of the Federalist Society. The Federalist Society is a nationwide network of judges, scholars, lawyers, and law students who believe that the idea of carefully circumscribed judicial powers is just as important today as it was for our founders. Through the Maurer chapter and others across the country, we promote and encourage public debate on key constitutional legal issues. Today we're excited to welcome Michael Berry of the First Liberty Institute and Professor Steve Sanders from IU Maurer School of Law. They'll be discussing American Legion versus American Humanist Association, the First Amendment at a Crossroads. It's not a very new joke or pun because the case involves a cross, but it was one that I figured I'd use. The way we'll do it is Mr. Berry will begin and talk for approximately 25 minutes, and Professor Sanders will respond to a 10-15 minute rebuttal, leaving the rest of the time for responses and questions from the audience. Now, before I introduce both guests, I'd like to acknowledge that I have some bias in this panel discussion. Mr. Berry is a graduate of The Ohio State University, and Professor Sanders is a graduate of that school up north, otherwise known as Michigan University. I'm a lifelong Buckeye fan, grew up as an Ohio State fan, but I'll attempt to let my feelings not affect this discussion. So Michael Berry is Chief of Staff of First Liberty Institute. He joined First Liberty in 2013 after serving for 7 years on active duty as an attorney with the U.S. Marine Corps. Among Mr. Berry's numerous positions within the Marine Corps, he deployed to Afghanistan, and he served as an adjunct professor of law at the United States Naval Academy. Mr. Berry continues to serve as a member of the Marine Corps Reserve, and in 2017 he graduated from Command and Staff College, where he was named a distinguished graduate. In his capacity at First Liberty Institute, Mr. Berry has participated in some of the nation's most high-profile religious liberty cases. As a recognized subject matter expert on religious liberty within the military, Mr. Berry has testified before Congress, and he's routinely invited to speak across the nation about matters affecting religious freedom within the military. Mr. Berry has been featured in numerous media outlets, including Fox News, Time, Good Morning America, Washington Post, Dallas Morning News, Atlanta Journal-Constitution, and the Houston Chronicle, among many others. Professor Sanders teaches constitutional law, family law, and constitutional litigation here at the Maurer School of Law. He clerked for the Honorable Terrence T. Evans of the 7th U.S. Circuit Court of Appeals. His scholarship focuses on questions arising out of the 14th Amendment's guarantee of equal protection and due process, with a special focus on issues affecting LGBT persons and same-sex couples. His teaching has been recognized with an IU Trustee Teaching Award and by vote of the law students as Outstanding Interactive Professor. Sanders writes regularly for the Huffington Post, the American Constitution Society blog, and SCOTUS blog. He has appeared on MSNBC and public radio's To the Point, and provides commentary and analysis for the radio show Bloomberg Law. He also frequently is quoted by print and online news media on matters on constitutional law and the Supreme Court. Please join me in welcoming our two speakers.
Thank you, Christian, and thank you to the Federalist Society chapter here at Indiana Maurer School of Law. It's really an honor and privilege to be with you all. I thought I'd begin first, obviously, by giving a quick introduction and a plug to my organization, First Liberty Institute, so that you all know who we are and what we do. Probably most pertinent for you all is that we do have paid internships as well, so I know that's always an area of interest to law students. But First Liberty is a national religious liberty law firm. We focus exclusively on defending and protecting religious liberties, and we do so for all Americans. We represent people of all faith groups and backgrounds, and that really is the sole area of our focus. We do so we refer to them as our four pillars. The four areas of law in which we primarily operate are in schools, educational institutions, in places of worship, in the military, obviously, and then finally in what we would refer to as the public arena or the public sphere. And that final area is one where this case arises. With that quick introduction about First Liberty aside, I thought I'd begin by, at the outset, the first thing that many of us have probably heard repeatedly about how hard cases make bad law, right? I think this case might provide an illustration of how easy cases, or supposedly easy cases, can sometimes make bad law. And the reason will hopefully become clear as we progress. Before we get into the actual facts and background of the case, how many of you have taken constitutional law? And in your con law courses, did you cover the Establishment Clause and the Free Exercise Clause at all, by a show of hands?
We don't do it in the first year.
Okay, all right. So good. I'll give you just a quick crash course on Establishment Clause background. Really, there's a lot we could probably spend an entire hour just talking about the Establishment Clause. For the purposes of our talk today, really what you need to know is this. At the time of the founding, right, when we had 13 colonies, those 13 colonies largely had, for the most part, distinct religious characters among them, right? We've all heard of how Pennsylvania was predominantly occupied by Quakers, Virginia was predominantly the Anglican Church, Maryland would have been a Roman Catholic Church, and Congregationalists in New England, et cetera, et cetera. There was no established national religion at that time, and when the framers were meeting and convening to draft the Constitution, they obviously, clearly wanted to keep it that way. Hence the reason and the purpose for the Establishment Clause, right? That Congress shall make no law respecting the establishment of religion. And it wasn't until this thing that we called incorporation, which came much, much later, that we saw that incorporated and applied to the states individually. So just keep in mind that background of what was happening at the time of the founding. Now, fast forward 150 or so years to 1925. Okay, that's when the Bladensburg World War I Veterans Memorial was constructed. Right, 1925. Right on the heels of World War I, also known as the Great War, and the memorial was put up to honor 49 men from Prince George's County, Maryland. Prince George's County is really on the outskirts. It's adjacent to Washington, D.C. 49 men who served in World War I, perished, and obviously at that time we did not have the logistical or technological means, transportation means, to get and to recover bodies and return them back to the United States as we do today. So these 49 men died serving in World War I, and their mothers, the mothers of these 49 men, wanted to put up a memorial to honor their service, to honor their lives, to honor their dedication. And they helped actually from their own pocketbooks pay for the memorial. The other people that contributed were our clients, the American Legion. So partially funded from these grieving mothers and with the help of the American Legion, they put a memorial approximately 40 feet tall on American Legion property in Prince George's County, Maryland, in the town of Bladensburg. Okay, so that should be the first flag that goes off in your head, right? You said they put it up on American Legion property. One of the first things you'll learn in con law and when you begin covering the Establishment Clause is, well, wait a minute, if it's on private property, then how, the government's the only one that can violate the Establishment Clause, right? Private parties cannot violate the Establishment Clause. So how on earth did this come to be a legal case? Well, that's interesting. On the tail end of World War II, as the Washington, D.C. metro area began to expand rapidly with the influx of lots and lots of people going there for the jobs, with obviously the massive acceleration of vehicle traffic, automobiles, right, that started to become ubiquitous across the country, particularly in urban areas such as Washington, D.C. There came this need to establish highway systems, expand the existing roads to accommodate the amount of vehicle traffic. Washington, D.C. was no exception to that. So the state of Maryland actually took the land that belonged to the American Legion, the land on which the Bladensburg Memorial sits, and they took it by eminent domain, this thing called eminent domain, which is where the government takes property that belongs to private parties, and they take it and it becomes government property. So that's actually how the memorial ended up in government hands. The memorial itself is like I said, approximately 40 feet tall. It has the letters U.S. inscribed on it. It also has the words endurance, valor, courage, devotion on it. And it has a plaque that basically commemorates and names the 49 men from Prince George's County who died and to whom it memorializes. It doesn't contain any other overt references to religion or God or the Bible or anything like that, but it is in the shape of a cross. And that's what gave rise, so it's been up for approximately 93, 94 years now. And for 86-ish of those 93, 94 years, it stood without any issues, without any challenges, well, at least without any legal issues. It certainly had its share of physical and environmental issues. Before we dive in, and again, another thing that I think would be interesting is I actually attended the oral argument, which was held at the end of February 27th, so it's been a little over a month now. It was one of the more interesting oral arguments, I think, for a number of reasons, which we'll get into. I assume that that's probably of more interest to you guys than anything, which is what did you see and hear? What were the colloquies and exchanges between the justices and counsel like? And I'm certainly going to get into that. But before we get into the Bladensburg oral argument, I think it's important to understand one case that comes before Bladensburg so you can understand the positions that we took. And that was the case called the Town of Greece versus Galloway, which is now roughly 5 years ago. The Supreme Court decided that case. The Town of Greece, New York had a long-standing practice of, before their city council meetings, they would have members of the clergy from the local community come in and give an invocation before their meeting. And that practice was challenged. It went all the way to the U.S. Supreme Court, and the Supreme Court said that that practice is okay under the Constitution, right? And the rationale that the court gave, at least the majority of the justices, was because that practice is so tied into the history and tradition dating back to the time of the founding. In fact, there are at least references to the Constitutional Convention itself when the First Amendment was being drafted. At those very meetings, they would have a clergy member come in and deliver an invocation before they convened. So, the thinking goes, if the men who drafted the First Amendment and the prohibition on government establishing religion actually permitted an invocation to be had before they actually wrote those words, then certainly they thought the invocation itself was okay. And so we kind of get this history and tradition angle. But then Justice Thomas also, in a concurrence, said, yeah, and I also don't think, I'm paraphrasing here, Justice Thomas said, I also don't think that this sort of tacit recognition of religion that's not the sort of activity that the founders intended to prohibit under the First Amendment, because it's not actually coercing anybody. There's no action by the government to coerce anybody, and as long as the government's not doing that in these invocations, then it's okay, right? And so they wanted to say, look, speech itself doesn't necessarily establish religion. Speech is actually, and religious speech is actually consistent with the nation's long history and tradition of diversity and pluralism, right? So there's your backdrop, right? History of the Bladensburg Memorial, history of the Establishment Clause, and keeping this Town of Greece case in mind about allowing even active speech, such as an invocation, to be permissible under the Constitution, so long as it's not coercive. Now we get to the Bladensburg Memorial, right? Passive speech. It's a passive display. It's not doing anything. It's just standing there. At the oral argument, we had 4 parties who had a vested interest in the outcome. All right, so you need to in your mind picture it's not just 2, right? For and against. You really had 4 parties who had a vested interest. The American Legion, which is First Liberty's client, right? They're the ones who helped put the memorial there, etc. The United States, represented by the Solicitor General, actually, ironically, First Liberty often works with major law firms on our cases and a co-counsel relationship. Our co-counsel firm in this case is Jones Day. Originally, the lead counsel from Jones Day who worked with us was a gentleman by the name of Noel Francisco. Mr. Francisco became Solicitor General of the United States, so obviously he was no longer able to continue working with us. So for those curious who have listened to the oral argument or read the transcripts, that's why you may have noticed that Jeff Wall was the person who argued and not Solicitor General Noel Francisco. So anyway, you had the United States who obviously has an interest in the outcome of the case as well, even though they're not a party. The state of Maryland, right, because they were also one of the defendants, because the memorial sits on Maryland state property. And then finally, the original plaintiffs, the American Humanist Association, who initiated the lawsuit. And here the positions advocated for really present the kind of array of the options that most pundits and commentators and practitioners see the court could choose from one of these three options. The first option, we call it the grandfather option, right? The court grandfathers in the Bladensburg Memorial and others like it, right? Really, really old ones that have been around for a really long time. But anything in the future, right? Future memorials or recent memorials will continue to be very fact-intensive, particularized inquiries. Okay? That was the position advocated for by the state of Maryland, who is represented by former acting Solicitor General Neil Katyal. So Mr. Katyal is saying, look, you don't need to do anything crazy here. Just this one comes in and others like it, and we'll deal with other ones, more recent ones or future ones as they come. Okay? The next option for the court is to rule that the memorial is unconstitutional. And how would they do that? They would apply this thing called the Lemon Test from the Supreme Court case of Lemon v. Kurtzman, right? Which really has a three-part inquiry. What's its purpose? What's its effect? And does it excessively entangle religion with the government? And really, it's kind of, morphed into what we now refer to a lot as the endorsement test. They are kind of separate, but most people would say, yeah, endorsement kind of is lemon, lemon kind of is endorsement. That's really the main thing you're looking for is, does this government action, or in this case a memorial that sits on government property, does it endorse religion in an impermissible way? So the lemon test did not seem to be popular with several of the justices, which I will explain why in a minute. And then finally, something else, right? Don't just grandfather this one in and leave practitioners to have to duke it out over all future cases. Don't apply the Lemon Test, because Lemon's this terrible vehicle, right? In fact, Justice Kavanaugh, during a colloquy with Neil Katyal on rebuttal, said, look, you keep telling us that we don't need to get rid of Lemon, right? We don't need to overrule Lemon. But this court has had multiple opportunities multiple occasions in recent time to apply Lemon, and yet we've repeatedly rejected the opportunity to do so. And now we have the opportunity to jettison Lemon, and you're telling us not to. Wouldn't this be the ideal case to apply Lemon? Right? So we're saying no, don't apply Lemon, get rid of Lemon, overrule Lemon. Don't just grandfather this one in either, because there's going to be, our client, the American Legion, they actually have lots of memorials, dozens, if not hundreds across the country. They don't want to have to keep fighting this fight over and over again. So do something else. And of course, what, right? Do what? We say, apply Justice Thomas's coercion test from Town of Greece which dealt with active speech. Apply that to passive speech, right? Because if active speech doesn't violate the Constitution because it's consistent with the history and tradition of the country, and it doesn't coerce somebody. Coerce, in our definition of coerce, be anything the government does to tangibly interfere with somebody's religious liberty rights. So as long as it's not coercing somebody to do something, then it should be permissible. It should be presumptively permissible. The reason being is that the founders' view of the Establishment Clause was not that a member of the community, even a so-called reasonable observer, would walk down a street or walk into a city park, a government-owned park, see something with which they disagree, right? And even if they sincerely and vehemently disagree and say, that offends me, I don't like that, that would not somehow give rise to an Establishment Clause challenge or an establishment of religion. The reason being is because this thing called the Lemon Test, this endorsement analysis, has created and caused so much confusion. It's sown so much confusion among practitioners, among, I would dare say, academics, and particularly among lower court judges, right? That it's really led to two real-world effects that are actually antithetical to the Constitution and to the First Amendment as the founders envisioned. The first real-world effect that is antithetical to the First Amendment is the following. If you are a government official, let's say you're the mayor of a city, the mayor of Bloomington, right? And the city of Bloomington decides they want to put up a memorial of some kind to honor something, anything, right? And that memorial somehow, in some way, invokes religious iconography, religious symbolism, religious imagery of some kind, no matter how slight, all right? Your fear as a mayor is going to be, your city attorney is probably going to tell you, look, if somebody sees that and perceives some type of offense, or that they're not welcome because of that memorial or that display, that statue, we could be sued, and because we might be violating the Establishment Clause, right? And as a practitioner myself, I've seen that scenario borne out dozens and dozens of times. Can't tell you how many times a mayor or a city council member, somebody has called me and said, hey, we're not sure if we should be able to do this or not. What's the black and white answer? And my response is, there's no black and white answer. Right? Depends on what jurisdiction you're in, what court state court, federal court, et cetera, et cetera. All right? So the end result, and often the result is that government officials take a default. No, we're not going to do it because I don't want to risk getting sued. Well, and so they end up not doing something. And I think you could argue that that's de facto religious hostility, right? Second, right, the second real-world effect, as Chief Justice Roberts acknowledged, is that this creates a nightmare scenario for lower court judges. Because in the Chief Justice's own words, as he was pointing out to opposing counsel for the American Humanist Association, when he asked, okay, what is the test that how should we analyze this case and other cases like it going forward? And her response, I'm paraphrasing, was, well, it depends who put it there, why did they put it there, what did they say when they put it there, how big is it, how loud is it, right? What else is around it, how many people have complained, how often have they complained? And he's just said, stop, hold on. And he said, if I were a lower court judge, and I was a lower court judge at one time, I look at this and I see this 20 or 30 different things I have to look at, and I'm going to throw my hands in the air and say, I have no idea what I'm supposed to do, all right? And for those who are skeptical of the Chief Justice's concerns, look no further than what the Supreme Court did on the very same day in the case of Van Orden versus Perry and McCreary County versus ACLU. Both cases dealt with a Ten Commandments display on government property. Okay? Ten Commandments display on state capitol grounds in Austin, Texas, Van Orden versus Perry. Ten Commandments display in the county courthouse in Kentucky, in McCreary County, Kentucky. All right, that was the McCreary County case. Supreme Court says Van Orden, the Texas Ten Commandments Monument, constitutional. The Ten Commandments Monument County Courthouse in McCreary County, unconstitutional. On the same day, they issued both of those decisions, reaching divergent outcomes. Practitioners look at that, and if you're not a First Amendment expert, you look at it and say, what am I supposed to do? Right? Government officials look at that and say, what are we supposed to do? The final point I want to make is one that before I turn it over to Professor Sanders, is that Justice Gorsuch also brought up a great point. First, well, he brought up two great points. First, he affectionately referred to the lemon test as a dog's breakfast, which has now kind of become the thing to say about lemon. And he said, look, hasn't it come to thank lemon for its service and send it on its way? But a better point that he made was, why is it that this is the only area of law? And he's talking about this thing called staining, right? And if you haven't covered this in Civ Pro yet, I think you will. That in order to file a lawsuit, you have to have staining before the court, right? And in a federal case, you have to have Article 3 standing. You have to show that you've somehow been directly harmed, right? Tangibly harmed by whatever it is that you're complaining about. He says, look, in no other area of the law that I'm aware of can somebody just observe something, all right? And the mere fact that they're offended by what they've observed, that gives them the right that gives them standing to sue and to challenge that. In every other area of law, you got to show physical harm, financial harm, or whatever. And at first, I was very concerned by that comment from Justice Gorsuch, because I thought, oh no, the court's going to punt this, and they're just going to say, oh, there's no standing, right? And then be done with it and deal with it on a later day. But the more I thought about it, and I went back and looked at our pleadings, I thought, okay, I think we're going to be okay here. And the reason is because, and just follow with me on this, if the Establishment Clause, if the framers had drafted the Establishment Clause to say, Congress shall make no law or take any action that offends any person, that would be evidence of their intent to confer standing broadly, right? But the Establishment Clause doesn't say that. It says establish. So the real issue isn't whether somebody should have standing to bring a lawsuit under the Establishment Clause. It's actually the manner in which, going back to the point that I've been making here, it's the manner in which our courts, and specifically the Supreme Court, has interpreted the Establishment Clause, right? And interpreted that word establish. And that's what's opened the door to this, for people to have standing. We call it offended observer doctrine, or sometimes unwanted exposure doctrine. And so that's what gives people the ability to go into court and sue, is they say, I see something, I don't like it, I want it removed, I'm going to sue. And then you combine that with how we've interpreted the Establishment Clause under Lemon to say, yeah, and we think that if the government's doing something that even endorses religion, right, then it's probably unconstitutional. So what we're advocating for, and what we think the better, clearer, cleaner path forward, not only for this particular case, but for all cases like it, is, again, adopt what the court did, and specifically what Justice Thomas said in Town of Greece, which is, as long as there is no actual coercion by the government, then it is presumptively constitutional. So I'm sure there'll be questions, but I want to make sure I give enough time for Professor Sanders. I'm happy to stick around and answer questions, and with that, I thank you.
Let me just see if this is going to cooperate. Okay. I want to show you a couple of images of the cross as part of my presentation. So I appreciate the invitation. I really appreciate what the Federalist Society does, its value to its commitment to dialogue, and so I always enjoy doing these kinds of programs. I want to make 3 points in my time. 1, I do not think the cross should be torn down. 2, though, I want to explore what I think are some troubling aspects of defending the cross as Mr. Berry's organization puts it, a question of religious liberty and freedom of expression about religion. And then 3rd, I want to talk just briefly about what this coercion test might actually look like and some of its troubling implications. So I would give 3 reasons for why I would be comfortable with the court saying the cross can stand. 1, as Mr. Berry says, the Establishment Clause was not incorporated as to the states until 1947. That's the weakest argument. I mean, that's not dispositive that anything a state did before that can't violate the Constitution, but it at least does indicate that the original memorial should not be understood as a sort of blatant unconstitutional act of defiance against the First Amendment that I think it would need to be seen as today. Second reason, I agree with an argument that's been made by 2 scholars, Walter Dellinger and Marty Lederman, that the cross is not objectionable because it commemorates a specific group of 49 citizens of Prince George's County, all of whom highly likely were Christian themselves. If it would not be a problem to have a field of 49 crosses marking their individual sacrifices, then a sort of collective cross like this shouldn't necessarily be thought to be a problem. As they write in their amicus brief, it would appear reasonable to view the Peace Cross not as a religious expression of the state itself, but instead as a respectful representation of a fact about the religion of those being honored. And 3rd, and most importantly, I would view this under the sort of historical grandfathering in approach that the court used in the Van Orden case about Texas, which is really more applicable because it was about religious monuments than Town of Greece is. The cross is sort of a piece of Prince George's County history. It looks like a war memorial, something somber and patriotic, rather than something that announces a particular form of Christian religion as the official creed. My understanding is there was actually some involvement with the cross being put there in the first place. It was on private land, funded by donations, but that state agencies had some role in actually building it and actually erecting it. At least that's what I understand from one of the briefs. But I show the image of the cross just to say I am a believer in Justice O'Connor's spin on Lemon, which is this endorsement test. Sort of would a reasonable observer who's familiar with the context of the display and the background facts of how the cross came to be there in the first place that a reasonable observer would not view it as an effort by the government to endorse Christianity and to deliberately make non-Christians and non-believers feel excluded. I mean, it is literally at a crossroads, which is why I thought the title for the program was interesting. I think if you saw this where it is in its context, you would understand this is a war memorial. It is a product of a particular time and a particular piece of history. And for that reason, for the sort of historically validating justification of the Van Orden case, which the court has used in a similar context, we should say, you know, given its history, given its context, this is okay, this passes muster. The McCreary case from Kentucky and Van Orden from Texas are not quite as arbitrary as Mr. Berry made them sound. I mean, there the context mattered. The Texas memorial had been there for decades. It was situated among other memorials that did not have religious themes but were tied into the idea of history and law-giving. The McCreary County exhibit of the Ten Commandments was a very recent plaque. It was clearly intended to be put there to sort of to project a religious message. So inquiry into context, history, and purpose is something that is very familiar to constitutional lawyers and does not mean that the two decisions that came out differently are necessarily arbitrary. But so let me then turn to my second point, which is why I'm a little troubled viewing this case as a question of religious liberty and free expression, which is how First Liberty's website portrays it. I'm not quite sure I understand how this case is about religious liberty. Religious liberty is usually something associated not with the Establishment Clause, but with the Free Exercise Clause. It seems to me that it must be, the view, if you see this as a question of religious liberty, it must be that those who are fighting to save the cross don't merely see it as a historical artifact worthy of respect, that's what I would argue, but rather that they do understand it as government expressing a message in support of a particular sectarian form of religion, and moreover that there is a constitutional right, that is religious liberty, to see government continue doing so. If this case is about religious liberty and free expression, the argument from the American Legion, it seems to me, must logically be the Establishment Clause must be understood to allow the government to embrace, support, and fund my exercise of religion. Why else would you say that your religious liberty is at stake in what the government decides to do with this cross? So as Mr. Berry said, the longer term aim here, at least among some of the litigants, the American Legion, some of their amici, is to change the standard, to abandon the Lemon test and the endorsement test, which are seen as creating too many barriers to government expression of support for religion, and changing it instead to this thing called the coercion test. Well, you know, no one exactly knows what the coercion test would mean if it were adopted in the sort of myriad contexts that Establishment Clause issues come up. But, you know, one source of guidance might be conservative lawyer Charles Cooper, who has represented some of the amici in this case, at least at the Fourth Circuit. I'm not positive about the Supreme Court. In an earlier context, he suggested that the coercion test would mean that a state, say the Indiana General Assembly, could declare Christianity as its official religion, as long as we said we're not going to enforce it, we're not going to do anything, we're just going to declare it our official religion. Mr. Cooper has said that would not be a problem under the coercion test. That would be okay. So imagine this. Hamtramck, Michigan is, I think, the first city in this country to now have a majority Muslim city council. Imagine the city council of Hamtramck passing a resolution saying, we encourage all citizens of our city to live their lives by the humane and peaceful tenets of Islam. We're not going to do anything to enforce it, we're just going to declare that. Come on, you know as well as I do that half of Fox News would have aneurysms on the air. You know, I won't prejudge the position of Mr. Berry's organization. Maybe they would defend it. But most of the same people fighting to save the Peace Cross in that situation would be screaming about protecting their religious liberty to dissent against what they would surely portray as a sort of form of hostile government religious tyranny. And so I think one thing this illustrates is that this coercion test makes a lot of sense if you're confident that you're already in the majority about religion and religious views. It is more problematic if you have no religion at all, or if you are in the minority. In a case called Lee versus Weissman from about 25 years ago, where the Supreme Court said that a high school couldn't have prayer at graduation, Justice Scalia vigorously dissented. Again, this is Justice Scalia's vision of the coercion test. His rationale was, you're not actually required to attend your high school graduation, so how could we say you're being coerced in some way if prayer takes place? So, to be clear, at least on that understanding, the coercion test would mean that the price of attending your own high school graduation would be to stand in respectful silence, even while your conscience rebels, as religious authority that you may not recognize and offers prayers that you may not agree with. I'm concerned that that is what religious liberty apparently means to those who are urging the court to be more accommodating to official government embracements of religion, by which we obviously mean majoritarian religion in this country. It is really the liberty of those who have the ear of government to have the government recognize their particular understandings as official and to make it difficult as possible for people of other religions or the 23% of Americans who have no religion at all to object to that. If you call that the coercion test, I think that's what it means as a practical matter on the ground. Finally, just one more point. If the Peace Cross is not just a war memorial, as again I would say it is, but is a potent symbol of government religiosity, which I've argued that if you think that this is a question of religious liberty, then it must have that meaning to you. And it does seem to me that it is coercive and that it would have to fail the coercion test. Is this really about tacit or passive expressions of religion? For Christians, the cross stands for the message of John chapter 3, verse 16. For God so loved the world that he gave his one and only Son, that whoever believes in him shall not perish but have eternal life. Or 1 Corinthians, for the preaching of the cross is to them that perish foolishness, but unto us which are saved it is the power of God. Or John chapter 3, verse 36, he that believeth not the Son shall not see life, but the wrath of God abideth on him. So it seems to me if you are a Christian, that is what the cross means to you. And an official government symbol projecting those messages is, to say the least, disparaging of those who don't share those beliefs. But to me, it also feels coercive. If that's what is really going on, again, from the perspective of those who are motivated to save the peace cross, because doing so is a matter of their religious liberty, their exercise of religion, then that means, it seems like that does mean that what's being advocated for is putting the government behind a message about death, salvation, the afterlife, and the consequences, eternal damnation, of non-belief or having different beliefs. And so if that is actually what the cross symbolizes, then it seems to me putting it there as a government symbol, as something the government is allowed to do, does begin to cross the line from feeling not just disparaging, but actually coercive. It is a message that you will be damned if you don't agree with the message, if you don't adopt the message that this cross symbolizes. And so again, for those reasons, I would say the cross should stand, but that the court's sort of by now somewhat well-established precedent of viewing religious memorials as having been essentially secularized and coming to stand for patriotism and for honoring the dead, avoids divisiveness, avoids the sort of disruption of civil peace I think we would have if the cross were torn down, but also avoids the disruption to civil peace and the divisiveness we would have, I think, if we take a view that does actually view this memorial as a projection of government religious message. So I hope I stayed within my time. I too would love to hear questions and discussions. So thank you.
Mr. Berry, would you like to give any response, or should we open it up for questions?
We can open for questions, that's fine.
Okay. Does anybody have any questions for me? Let's start in the back there.
I have a question just to make clear the difference in, or to help further make clear the difference in your two positions. I'd like to ask you a hypothetical. I'm a law professor, so I'd like to ask you a hypothetical that Mr. Berry's presentation started to raise. So, Mr. Berry, I don't know if you're familiar with Bloomington at all, but I don't know if you've seen the square downtown, the beautiful square.
I think so, yeah.
Yeah, in the middle of Bloomington. That's actually county courthouse and county property. And then Dunn Meadow, we have at IU, a big, beautiful area where we have rallies, protests, gatherings. So simple and hypothetical, it's also our 200th anniversary right now of IU, the county, the city, so we're celebrating that. So what if the city and the county and Indiana University said to commemorate, this great time and our heritage, we're going to erect one of those, a cross like that, and thanks for the image there. So we're going to erect that at the county courthouse in the center of Bloomington and at Dunn Meadow on IU Public University property. Also put up a 10 Commandments as part of the display, and that's our commemoration of the 200th anniversary. So I'm curious, I'd like to hear from Professor Sanders under current doctrine, what would the court say? And then under an adoption of Justice Thomas's coercion approach, what would the answer be?
Yeah. So my understanding is that, again, the two cases that would be most relevant would be the McCreary County, Kentucky case about the recently placed 10 Commandments plaque in the county courthouse versus the Van Orden case from Texas about the 10 Commandments memorial situated among other memorials, and it's been there for decades and decades. To me, what you described would seem very much to be controlled by the McCreary County case. There's no obvious, you didn't say, Dawn, what is the reason why they've chosen a Christian symbol?
Celebrate our bicentennial and the history and heritage of our
Then the message that clearly sends is that everyone of any significance who's been connected with Bloomington or Indiana University was Christian, shares the values of Christianity, and that somehow an expressly, powerfully Christian message of the cross is the most appropriate way to commemorate the bicentennial of the university. I mean, again, that seems to be clearly settled by the McCreary County case. No, this is just being put there to project a message, a government, not just endorsement, but a sort of, a compulsion, an expression of support for religion, rather than something that, again, is contextualized with other memorials to lawgivers or memorials of people who have died in the cause of Bloomington or Indiana University of other religions. So that's my understanding. I think that would be an easy case under current doctrine.
Sure. So a similar hypothetical was actually presented during oral argument, and there was a nice exchange. I believe it was between Justice Kagan and Jeff Wall, representing the United States. And Justice Kagan laid out this hypothetical and said, well, let's say there are 5 crosses, right? One is identical to this one, same facts, same circumstances, etc. Another one that is a more recently placed World War I memorial. Another one that is a memorial to all veterans of all wars. Another one that is a memorial to some type of tragedy or event, a school shooting, 9/11, something like that, but not necessarily with a military context. And then finally one that it's just a freestanding cross. That's all it is. It's just a cross with no other context around it. Which of those, if any, are permissible and which ones aren't? So under the coercion test, for which we advocate, and I think Justice Thomas advocates, the first 3 are clearly presumptively valid and constitutional, right? The 4th one, I think also leaning towards presumptively valid, maybe need to know a little more. And then the 5th one, if I recall, Mr. Wall's comment was something like, we should maybe talk. So in the hypothetical that you've given, with the city of Bloomington putting up a freestanding cross and putting up a 10 Commandments monument to honor the bicentennial of Bloomington and is it Monroe County?
Mhm.
Okay, Monroe County. I would echo Justice Thomas and Mr. Wall and say I would say that that's presumptively valid under the coercion test. Because, and here's an interesting point: the American Humanist Association, in its I believe in an amicus brief that it submitted in the Town of Greece case, actually made the argument that the speech at issue in Town of Greece, right, a member of the clergy giving an invocation, is far more. It should be unconstitutional because it's more coercive than a passive display would be, right? I don't know if they used the word coercive because I don't know that they would have conceded that ground, but that was the gist of the argument that it should be more likely to violate the Establishment Clause when it's active speech given by a human being to people in the audience versus a passive display, which, as Justice Thomas pointed out, you're free to just go the other way or not look at it or move on with your life. It's not making you or coercing you to do anything. It's not tangibly, as we've invoked, tangibly interfering with anything that you have the right to do or not do.
It seems to me that the difference between the coercion test and the establishment test is one is preventing you from doing something like negative, essentially, and the establishment test is you can't do something like a positive action, right? And my issue is like why is, and they're both dealing with how these symbols are interpreted. So I'm wondering why would the coercion test be simpler and easier to apply for lower court judges than the establishment test if they're both interpreting these symbols?
I mean, if I understand the question correctly, I think the reason it would be simpler and cleaner for a lower court judge is because, getting back to Justice Gorsuch's point, is it kind of cleans up a lot of the standing issue, right? That there would be far fewer cases brought because you would have to show some type of tangible harm or tangible interference with even a negative liberty interest, as you've brought up, right? As opposed to simply because right now all you have to do is say, I'm offended by it, and that's the triggering mechanism, right, that gets you into court. Whereas under the coercion test, simply saying I'm offended by it isn't enough. I now have to present some kind of tangible evidence that my liberty interests are now being interfered with by the government. And there's contexts where, as Justice Scalia, I believe it was in the County of Allegheny case, he gave up the hypothetical of, we permit the government to, we've ruled that the government can print "In God We Trust" on our currency, and that's constitutionally permissible, right? So there is, and then of course he asked the question, what if we had printed instead "In Jesus Christ We Trust" on our currency? Now you're obviously tiptoeing closer and closer to that coercion line where the government is now telling you and threatening, damnation if you don't accept that view. And as somebody who served in the military context as well, I know, in the military, you have government speakers in the form of superior officers who engage in speech all the time, speech that I would presume many subordinates are offended by, right, and perceive offense. And in fact, you probably have heightened issue concerns because of the so-called captive audience issue you have, right, where you're a subordinate. I can't just turn around and walk away. I can't tell the guy, hey, stop talking. I can't say, hey, I don't like what you're saying, because he's perceived as my superior. But yet, those challenges are often fail as well, because it's just accepted that, in the case of the military, it's the whole you're in the Army now. Sorry, you volunteered. This is what you volunteered for and signed up for. But I just use that as an illustration for it in a different context, that we are exposed to things that we don't like and that we find offensive all the time. But I myself, can probably come up with many examples where that happened in the military context. I don't think that should give me the right, though, to file an Establishment Clause claim or some other type of claim, a negative free speech right or something like that, to not have to be exposed to that simply because I don't like it.
But again, I worry that's confusing the requirement for standing with the requirements for actually prevailing on the merits. There are lots of things that people, the Texas monument, lots of people would say, I'm offended by that, and they might come into court and try to challenge it, but the court settled, again, for these historical reasons, sort of grandfathering in the context in which the monument appears. The court has said, no, that does not violate the Establishment Clause. I think my concern with this coercion test is it's sort of tied in with this, sort of purely historically sort of looking backward orientation of thinking about constitutional rights. That one is not the way the court does substantive due process. It's not the way we think about free speech. It's not the way we think about the Equal Protection Clause today. And you have to ask yourself, is it really appropriate to say that you can just walk by the kind of monument that Professor Johnson described, and if you don't like it, you just go on with your business. If you are a Buddhist, a Muslim, a Jew, a non-believer, to sort of lightly say, that doesn't mean anything to you, so there is no coercion. It's inconsistent with the idea that I think the Establishment Clause also has to protect dignity interests. It has to have a certain element of what civic equality means in this country. And, again, once again, ask yourself with the sort of Hamtramck example I gave, do you really think that most of the people who are, this comfortable with the idea that it's not a problem unless it amounts to coercion would be racing to defend the Muslim City Council of Hamtramck if they inaugurated a law that said, we think all people should live according to Islam. We're not going to coerce anybody, just our view. I just don't take that idea seriously.
Now, I'll offer a quick counterpoint to that, and then we can take the next question. I certainly think that's a fair point to make. The one thing that concerns me is if we adopt the grandfather clause approach, right, or if the court adopts the grandfather clause approach, it's kind of the law of unintended consequences. That, as somebody pointed out to me, if you look across the national landscape, I haven't run the numbers, but I would expect that at least 3/4, if not much higher percentage of the veterans memorials and monuments of that nature are of the Judeo-Christian nature, right? Classic characterization. You probably crosses, 10 Commandments, things like that. References to God, perhaps even references to Christ. And if we only grandfather in the really old ones, right, and we say but no new ones for those very reasons, then the practical real-world effect is that the only thing that will be left, or the predominant imagery left in our country, will only be Christian memorials and crosses and 10 Commandments displays. So that simply because those just happen to be really old, right, and so that in other words, only the old stuff, nothing new comes in. As the country begins to evolve demographically and become more diverse and pluralistic, you would expect and presume to see new memorials might be more pluralistic and diverse in their character. And I'd say that's perfectly fine. I grew up in the Bay Area in California. I'm used to pluralistic, diverse, communities, and that's totally fine with me. My concern is that if you set a cutoff point and say anything after this date, 1925 or whatever arbitrary point we want to make, then and only things that were older than that come in, again, I would expect 75, 80%, perhaps even more, are going to be crosses, 10 Commandments, etc. So that's all you're going to be left with. And so it ends up having almost this unintended hostility towards minority faiths.
Are there really that many, though, that are left that are on public land? I mean, are there that many crosses that can even be reached through litigation? Yeah, there are lots of those crosses, but they're typically not on public land, and they're not going to present an Establishment Clause issue. I wasn't aware that there are like 70 or 80 more of these out there waiting to be litigated.
It doesn't just have to be static displays such as memorials, crosses, 10 Commandments. The Third Circuit is dealing with a case of a county seal, in the Lehigh County case. So you have the silhouette of a Franciscan chapel that dates back to the founding of that community. There's another one, I think, in Steubenville, Ohio, that dealt with that. So there are, I couldn't put a hard number on it, but I would say, and I think actually in the Lehigh County case, one of the amici identified like every instance they could come up with where, some type of historic symbol would be affected. We're talking definitely into the hundreds. So yeah, I mean, not every nook and cranny of the country, but certainly I think it's fair to say ubiquitous. I think.
I think we have time for one more question.
What significance does it have that this was privately built and privately funded and then acquired by the government versus the hypothetical that we had that it was built by the government currently rather than kind of transformed into government property? I haven't examined the First Amendment that closely. I have not class, but that seems like a pretty huge distinction.
Well, the simplest answer is that if the legal challenge arises at the time that it's government property, then under current doctrine, that gives rise to Article 3 standing, right? Because it's currently in government property, right? I'm not aware of any cases where, well, I'm not aware of any because there wouldn't be any, where there was a challenge to privately owned property that then later, became government property. So, a intrepid young law student did ask me, well, if the government took this by eminent domain and then the court declares that the memorial is unconstitutional, then wouldn't that be an unconstitutional taking? Right? and isn't the remedy for an unconstitutional taking reversion to the original? And I said, well, that's a very interesting theory. I'm not sure it quite works that way, but so I give kudos to that student for thinking of things that way.
So as I said, at least in one thing I've read indicates that there was that some Maryland government entities were actually involved in constructing or helping to construct the memorial, that in one way or the other it has continuously had some government association. But you're right, I mean, it wasn't acquired, it didn't become public land until later. I think that's significant, but again, my lens is the endorsement test, that if you're aware, I think the point you're making, Charles, is you're aware of the history, you're aware of the context, you're aware of how this was private property and has now become public property. And I think another issue is that government funds are actually used to maintain it currently, so that's another hook. But if you're aware of that history and that context, it's not a bright line rule, but a reasonable person, a reasonable observer would not say that exists because Prince George's County wants to declare Christianity the official religion. No, it's a war memorial. So,
All right, let's give a big.
I was going to, one final point, because I was remiss in my duties. I know that the most important thing people want to know is what's your prediction, right, on the case. Everybody wants to know what the court is going to do. I think if it were just simply to grandfather in this memorial, we're probably looking at 7-2, maybe even 8-1 in favor of preserving the Bladensburg World War I Veterans Memorial. But really the question before the court, at least from our perspective, is, okay, but what about all the other memorials, right? What are you going to do about everything else going forward? And our proposed method for dealing with that is overrule Lemon and apply the town of Greece framework to these cases. On that question, I'm obviously less optimistic. I would say if we prevail on that question, it may be 5-4. Chief Justice Roberts is going to be the swing vote on this, I predict, and it's anybody's guess as to which way he can come out.
Can I make one last real quick point? I would agree with all of that. I wouldn't disagree with any of that. And just to be clear, as a matter of, because when I teach my classes, I like to talk about litigation strategy and constitutional law. So, this case was not brought by religious liberty advocates to try to expand the standard. This case was brought by the residents and represented by the American Humanist Association. I mean, to me, as somebody who is a little more on the separationist side, that's like lousy litigation strategy. It was a huge mistake to bring this case because that there are some justices there, Alito and Gorsuch and Kavanaugh maybe just waiting for a case like this to, change.
But in fairness, they weren't there at the time the litigation was initiated.
Yeah.
And who would have predicted?
Yeah, but I still think it was a mistake to bring this case because the handwriting was kind of a flaw. Anyway.
Let's give a big thank you to our speakers.